Article 3 of the Constitution is about the judicial branch. And what you're going to notice about Article 3 is that it's much, much shorter than even Article 2 was. So you can see just by the number of words that were used in the Constitution on the legislative branches compared to both the executive and the judicial branches, that the legislative branch is the most important. It was also the first article because that's where the people's representatives are. Now, one of the other things you should have noticed in Article 2 is that the president doesn't really have a whole lot of authority. Most of what he does is just executing the laws, and then he also has a large role in foreign diplomacy. Now, as for Article 3 is going to set up the Supreme Court of the United States, also known as SCOTUS. Okay? In Section 1 here, it says the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. So going back to Article 1, you were taught that the Constitution only sets up a Supreme Court. All other courts, all of the inferior courts in the federal system, so the appellate courts and the district courts, are set up by the Congress. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. So judges can continue on in their roles for a lifetime. So once they're appointed, they're on the bench. They can only be removed through an impeachment process. So the impeachment process is the same as what you saw listed in Article 1. The House of Representatives would have to accuse, and then the Senate would have to try and convict by a 2/3 majority and then remove. Now, one of the reasons why the founders would have done this, to give justices a lifetime appointment, is to guarantee that you don't have a president or a Congress who disagrees with the judge's viewpoint. So the judge is supposed to be interpreting the Constitution based on the Constitution itself or based on previous laws. And they didn't want a situation in which an unpopular decision from the court was then punished by a president who decided to fire the Supreme Court justices or by a Congress that just decided to remove all of the judges. So this gives the judiciary an independence. We call it an independent judiciary because it is not bound to anything from the president and it is not bound to the Congress. They have the ability to make decisions for themselves, affecting the other two branches, but without pressure from those two branches to come to a decision that the other two branches would want. This again is an example of the system of checks and balances. Now, they also are going to receive a compensation from the Treasury of the United States, which shall not be diminished during their continuance in office. So again, the reason why their salary cannot be dropped is to prevent the Congress or to prevent the president from taking punitive action against the judges in case of a decision that they don't like. Now, you will see on occasion presidents that will challenge a Supreme Court decision. They will challenge it in the media. They will challenge it publicly. It's considered bad form to do this because it's almost as if it's a form of intimidation against the judges. But again, the judges are independent of the other two branches, so they really don't have to worry about that too much. Both President Obama and President Trump came out very, very publicly against decisions that they didn't like. In one case, in President Obama's case, there was actually a reaction from Justice Antonin Scalia. He came out in the media and publicly gave the president a tongue lashing for trying to interfere in judicial matters. Now, the federal court system itself is broken down into appellate courts and district courts. So district courts are going to be the lowest rung of the federal ladder, and that's where cases are going to be heard. And we'll go over which cases are heard by federal courts a little bit later. But the district court is that first court where you're going to see cases appear, and then whoever loses that case in the district court is pretty much guaranteed to appeal. And anytime that a district court case is appealed, it is then going to go to the appellate court or to the federal appeals court. Then if the loser appeals again, then that could go on to the Supreme Court's docket. Now, there are thousands of cases every year that are appealed to the Supreme Court, but the Supreme Court is only going to hear a handful of them. We're talking maybe in the neighborhood of 10 to 20 cases per year. And then the Supreme Court is going to decide on those 10 to 20 cases. Now, what the Supreme Court could do is they could review those cases and say, we want to send those cases back down to the appeals court or to the district court or whomever, and we want you to revisit the decision that you came to. They're not actually going to make a decision themselves. They're just going to tell the federal judges below them, go ahead and take a look at this case again and see if there are any other new facts and evidence. Then, the next thing that you guys need to know is that the current makeup of the Supreme Court is 9 justices. There is nothing in the Constitution that says that there have to be 9 justices. The only thing about it is you want to have an odd number, because if you have an even number, think about you could have a lot of ties. So we normally have an odd number of Supreme Court justices unless there's a vacancy that has not been filled yet. And there have been times when we've come to 4-4 decisions because there was a vacancy that hadn't been filled. Now, sitting at the top of the Supreme Court is the Chief Justice. Now, we've already talked about how the Chief Justice, in the case of an impeachment of the president, is going to preside over the impeachment trial. Aside from that, the Chief Justice it's not like he gets 2 votes as compared to everybody else's 1. He may have some special authority in the court, especially during presentation of oral arguments. But we're not going to really discuss any powers the Chief Justice has. You just need to know that the current Chief Justice is John Roberts. And John Roberts was appointed by President George W. Bush. Then you have Neil Gorsuch. And Neil Gorsuch, Clarence Thomas, and Samuel Alito are all, as well as Brett Kavanaugh and Amy Coney Barrett. So we have Roberts, Gorsuch, Thomas, Alito, Kavanaugh, and Barrett were all selected by Republican or conservative presidents. So the expectation would be that their interpretation of the Constitution would be a conservative one, which means that they would normally be strict constructionists, which means that they're going to go by the letter of the law. Whatever the words in the Constitution mean, that's what they are going to go by. So we hear this often called strict constructionism or originalism or textualism. So they're going to go by the text. They believe that the original meaning of those words is what needs to be used in order to interpret the Constitution or to interpret laws that were written decades ago or even centuries ago. Now, on the flip side of that, you got Elena Kagan, Sonia Sotomayor, and Stephen Breyer, who were all selected by Democratic or liberal presidents. So either Bill Clinton in Breyer's case or Barack Obama in the case of Kagan and Sotomayor. Now, they are expected to give liberal decisions on most things. And these 3 do tend to vote as a block. And when Ruth Bader Ginsburg was alive, then she would have voted with those 3 as well. So the liberal side of the court tends to vote as a block. Whereas sometimes you see conservative justices making decisions that you wouldn't have normally expected to see them make. When we talk about the liberal judges, then we're talking about loose constructionism. Liberals tend to believe that the Constitution is what we would call a living document, that it has to be adjusted for the time and the place that it now exists. Whereas the conservative judges would say, if the Constitution is going to be adjusted, or if language that was written in laws is to be adjusted, then it needs to be adjusted by the Congress, or it needs to be adjusted by the amendment process. The liberal justices tend to think that they can take the meanings of words and apply them in different ways. And we would use the term be very liberal with the meaning of words and apply them in different ways for a document that was written 200 plus years ago, and maybe make those words fit our world a little bit more. Okay, so you have two very, very different ways of viewing the Constitution. One is the living Constitution, and the other is that the Constitution is set in stone, and if it's going to be amended, then it has to be done through the amendment process. It's not going to be amended there in the court, and it can't be amended just through Congress, because Congress does not have the authority to amend the Constitution. Now, going back to what we talked about with how the district courts and appellate courts are set up, there are two different ways in which a case can reach the United States Supreme Court. One is going through the federal court system, and one is going through the state court system. So if you're looking at the U.S. district courts, again, there's 94 of them, and then there's 13 separate regions for the U.S. appellate courts. And a case can make its way through the district courts, up into the appellate courts, and then eventually make it to the Supreme Court. So any case that had to do with Obamacare in the past 10 years, all of those cases would have come up through the federal court system because it was a federal law that was being challenged. Now, the other way is to go through the state system. So the first place that the case would go through would be the state trial courts. And then once it went through the state trial courts, then it would go to the state appellate courts, which exist in 39 of the 50 states. Then once it got through the state appellate courts, then it would go to the state Supreme Court. And once it had gone through the state Supreme Court, then it could be challenged in the United States Supreme Court. So perhaps the most famous ruling that came through the state courts was that of Roe v. Wade. Now, Roe v. Wade was a case that came before the court in 1973. And what had happened is there was a woman in Texas named Norma McCorvey who had gotten pregnant. And she did not want to have her name used. She wanted her case to go through the courts anonymously. So they assigned her the name of Jane Roe. So kind of like John Doe, Jane Roe. And so McCorvey sued the district attorney in her region in Texas. And that man's name just happened to be Wade. And she was suing him over the enforcement of abortion laws in Texas. So in 1973, I'm not sure that you could get a legal abortion in any of the 50 states. And so she was suing to be able to seek a legal abortion. Now, in reality, she never would have been able to get a legal abortion because what's going to happen is it takes much, much longer than 9 months for a case to make it through the state courts and then to appear at the Supreme Court and then to be decided on by the Supreme Court. So really what she was doing, she was not going to be able to get an abortion for herself. She was seeking to overturn the law so that other women would be able to get an abortion. It goes through the state trial courts, and in the state trial courts, Wade wins. So McCorvey then appealed to the appeals court or to the state Supreme Court. She lost at every level in Texas. And so she then appealed the decision to the United States Supreme Court. and the United States Supreme Court took it up and combined it with a bunch of other cases, but it came to be known as Roe v. Wade. So what happened is, a lot of times what you'll see is that one case from this state and another case from this state and another case from this state, they all get combined into one case that is going to go to the Supreme Court of the United States and is going to be argued there. Another example of that would have been Brown v. Board of Education. There were several states or several educational districts that were being sued throughout the United States. It just all got into the Topeka, Kansas. It was all combined into the Topeka, Kansas decision. So Jane Roe, or Norma McCorvey, she appeals to the United States Supreme Court, and the United States Supreme Court ruled in her favor. And so what that did was it took all of the abortion laws preventing abortion in all 50 states, and it basically wiped all of them out. And overnight, abortion became legal in all 50 states. When we're talking about politics and we're talking about elections, this is the one case that you really, really need to know, because there are what we call single issue voters that will only vote based on that one issue. So if they're against abortion, then they'll vote for the Republican. If they're for abortion, then they'll vote for the Democrat. And they don't care about any other issues. So that's why this is such an important case, and it's important to know how it got to the Supreme Court and how the Supreme Court overruled the state laws that were in effect. All right, so in Article 3, Section 2, it's going to describe in which cases federal courts have jurisdiction. So in which cases will a case go to the federal courts, or will it go to the state courts? You may have heard the term jurisdiction if you've ever watched cop shows or legal shows, and somebody comes in and says, "You need to get out of here, this is my jurisdiction," okay? They're just talking about who has legal precedence, or who has the legal right to investigate or to handle a particular case. So it says, the judicial power shall extend to all cases in law and equity arising under this Constitution. So if it's a constitutional issue, it's a federal issue. The laws of the United States. So if it is about a law of the United States, so like Obamacare, the Affordable Care Act is a U.S. federal law. Therefore, any challenges to that law go through the federal system. Any treaties made by the United States. So if we were talking about the Treaty of Versailles, although the Treaty of Versailles was never signed on to by the United States, if it was a treaty made by the United States, then it would be under federal court system. If we're talking about NAFTA, the North American Free Trade Agreement, that would go under the federal court system. It continues on with, or which shall be made under their authority, to all cases affecting ambassadors, other public ministers, and consuls. So anything that has a federal official is going to go to the federal court system. To all cases of admiralty and maritime jurisdiction. So admiralty and maritime jurisdiction, that's talking about the high seas, on the ocean. Anything that regards the ocean, any issues that were piracy or felonies that were committed on a U.S. flagged ship are going to go to the federal court system. To controversies to which the United States shall be a party. So another nation is suing the United States. That's going to go to the federal courts. To controversies between two or more states, and there are several times when this has occurred. I'll give you an example of the state of Georgia decided to dam the Chattahoochee River. And they wanted to dam the Chattahoochee River in order to keep more water in Georgia, which could then be used by residents of Georgia. Well, the issue with this is that the Chattahoochee River flows from Georgia and Alabama into Florida. And by damming the river, the Chattahoochee River's flow was really, really decreased. And so there was very little water that was actually making it to the Gulf of Mexico. Well, in where the Chattahoochee River it becomes the Apalachicola River, where the Apalachicola River empties out into the Gulf of Mexico, there are oyster beds there. And those oysters need that fresh water mixing with the salt water to form brackish water in order to be able to survive. And so what happened is that by damming up the water in Georgia, there was very little flow into the Gulf of Mexico. And so these oyster beds were really affected. Well, there were oyster farmers who relied on those oyster beds to make a living. And so they sued, or Florida sued the state of Georgia about damming up the river and allowing more water to flow into Florida so that these oyster beds would not be affected. We've also had a similar thing happen with the Colorado River. The Colorado River has been dammed up at Hoover Dam, and water is diverted from Lake Mead into Southern California and into Las Vegas, because those areas are, if they're not deserts, they're pretty much deserts. And so all of that water is diverted from Lake Mead into Southern California and Las Vegas in order to provide drinking water, in order to provide water for irrigation, for farmlands, or just so people can have nice looking yards in Los Angeles or Las Vegas. Well, so much water has been held back that very little water actually makes it into Mexico, where the Colorado River empties out. And so if you look at the mouth of the Colorado River, there's barely anything there now, where it should be something like a mile wide river mouth. This is going to have an effect on the economics and the well-being of Mexicans who are living near the mouth of the Colorado River, because they are now no longer going to be able to fish or do what they were doing in order to survive. So if the Mexican government were to sue the United States government over that, again, it would go to the federal courts. The federal courts also have jurisdiction between citizens of the same state claiming lands under grants of different states, as well as between citizens of different states. So anytime that two states are involved, it's going to go to the federal court system. Okay, the trial of all crimes, except in cases of impeachment, shall be by jury. So impeachment is again going to go before Congress. The articles of impeachment are going to go to the House of Representatives, and the actual trial is going to be held in the Senate. But in any case that there's a crime that's committed, you have the option of either having your case heard by a jury or having your case heard by a judge. In almost every case, it's better to have your case heard by a jury, because it's possible that they could be more sympathetic to you, as opposed to a judge who's there to strictly go by the law. Such trial shall be held in the state where the said crimes shall have been committed. So again, this goes to jurisdiction. So if a crime is committed in Florida, the trial is not going to be held in Georgia if it's a state crime. Okay. Now, if a crime is held if a crime is done in, say, Pinellas County, or actually, I'll give you an example of one that happened in Orange County. There was a girl named Casey Anthony a few years ago who was accused of murdering her daughter. Her daughter was 2, 3, 4 years old, somewhere in that range. And it was a big time media event. Everybody across the country knew about Casey Anthony and what had happened to her daughter. So Anthony is going to be put on trial, but because everybody in Orange County has heard about it, there was a fear that the trial could be tainted by prejudiced jurors. So what they did was, instead of having the trial held in Orange County, I believe it was brought over to Pinellas County, which is where St. Pete and Clearwater are, and the trial was held there. simply because they were not going to be able to find a pool of jurors in Orange County who basically hadn't already made up their mind about what this woman had or had not done. So they brought it to Pinellas County, where there was going to be the potential for a jury pool to actually be selected. So that was a case where jurisdiction was shifted in the case of the trial. Now, who actually investigated the murder? That would have been the responsibility of the Orange County Sheriff's Office or the Orlando PD or whichever municipality would have had jurisdiction there. It goes on to say, but when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. There, I don't have an example for you. The only thing I could possibly think of is maybe if it was a maritime situation, or if the crime was committed on an airplane or something like that, then it would probably be directed as there's probably some way that Congress has said this is where anything that has any circumstances like that is going to be held. In Section 3, it goes into treason. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. So there are only two circumstances in which somebody can be accused and tried for treason. Those two circumstances, again, are if a person levies war against the United States. So if you pick up a gun and go and try to murder Americans or kill Americans in war, or kill American soldiers in war, then you can be tried for treason. The other way that you could be tried for treason is by giving aid and comfort to the enemy. And notice that it is aid and comfort, okay? It's not aid or comfort. It has to satisfy both. Now, aid could be something like Benedict Arnold taking the plans of the U.S. military and taking them to the British so that the British would know how we were going to try to attack them. Therefore, they could come up with a defense. That would be both aid and comfort to the enemy. Now, there are some examples of both levying war and providing aid and comfort. In levying war, there was a man named John Walker Lind. He is known as the American Taliban. The Taliban is a group of people, who were in control of the Afghani government prior to the U.S. invasion of Afghanistan in 2001. The Taliban, these are not nice people. Okay? They are extremists. I'm qualifying this. They are extremist Muslims. Okay? Not to say that they're Muslims and that they're bad. No, they are extremist Muslims. They torture, they kill, they murder for what we in the West would see as no good reason. And so they were a very oppressive regime in Afghanistan. Now, they were allowed Osama bin Laden and Al-Qaeda to train in some of the more remote regions of Afghanistan. They knew that they were there. They knew that they were planning attacks on Americans and American allies, and yet they did nothing to stop it. There were people in the United States who were sympathetic to the Taliban. And one of those people was named John Walker Lind. So John Walker Lind decided to up and leave California and go to Afghanistan. And when he got there, he found the Taliban, or he found Al-Qaeda, and he was trained by one of those two groups, and then he was found on the battlefield trying to kill Americans. So he then could be tried for treason because he took up arms against the American military. Now, a second example of providing aid and comfort would be Julius and Ethel Rosenberg, perhaps the two most famous spies in American history. The Rosenbergs were caught spying for the Soviet Union back in the 1950s. Now, what I believe they were eventually convicted of was espionage, but they may have been able to go on trial for treason as well. The penalty for treason is death. So if you are tried and convicted of treason, you will be executed. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act. So overt means it's out in the open. 2 people saw you do what you did. That's one of only 2 ways that you can be convicted of treason. The second way is if you go in open court, so with witnesses, and you confess to what you did in that open court. So we're not talking about you're in an interrogation room and somebody beats you until you give a confession. No, we're talking about you are standing in an open court and you willfully provide testimony, or you willfully confess to doing what you have been accused of doing. Those are the only 2 ways that a person can actually be convicted of treason. Otherwise, you would have to find other charges. So like the Rosenbergs may not have confessed in open court. They may not have had 2 witnesses to say, I saw them do what they did. But what they were convicted of was espionage, which does not require as much as what treason does. And they were executed for being spies. They were executed for being guilty of espionage. Now it goes on to say the Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. Now, corruption of blood, I'm going to have to go back and take a look at this, but I do believe that corruption of blood means that if you are found guilty of a crime, say of treason, then only you can be convicted of treason. That treason cannot then be cast on to your children and your children's children. So just because the father was a traitor does not mean that the children are traitors, which has been the way things have been done in certain societies throughout history, where if the father was convicted of treason or the father was found to be a traitor, then the kids were also not expected to be, but were also basically given that title of a traitor as well. So what constitutes treason? Treason is levying war against the United States or in giving the enemy's aid and comfort. The conditions that exist for someone to be tried for treason: 2 witnesses that saw the overt act or an open confession in court. Punishment for treason is death. And what punishment is prohibited? Corruption of blood is the only thing that is going to be prohibited in the sentencing phase.